All right, we are going to finish off International Law Topic 6 with a close, hard, in-depth look at the Sharn Importing Ltd. Versus Babchuk case. Although this is a Canadian case in the sense that it involves Canadian jurisdictions, because it goes across provincial boundaries, the same laws and rules that are applied to international cases involving two different countries were applied in this particular case itself, and it's got everything. Okay, so the first time we bumped into Sharn Importing was on slide 56 when we were talking about the sources of international law outlined by the International Court of Justice in Article 38 of the convention that established it. The fifth such rule was that the courts could look at judicial decisions and decisions of the teachings of the most highly qualified publicists of various nations. And this is, in fact, evident in that case. The next slide I wanted to point out, of course, is that this deals with 61, where we talk about civil matters. Okay, it's not a criminal matter, it's a civil matter, it's a contractual dispute. Jurisdiction, forum, and law. How do we work it out? Well, in Sharn Importing, the plaintiff was in Quebec, the defendant was in British Columbia. The plaintiff elected to start the action in BC against the defendant. The defendant defended by filing a statement of defense in BC. So automatically the BC court has jurisdiction. How? Well, this is an in personam jurisdiction. And if we look at slide 62, it lists those factors that the courts can take into account for determining whether or not it does have valid jurisdiction. And the first one is nationals of the forum state. What's the forum state? BC. So obviously Babchuk is from BC. Bingo, there's one. Natural persons physically present in the state. The company is in Quebec, it's not physically present, no. Natural persons domiciled in the state, no. The company is registered in Quebec, so it's deemed to be domiciled there. Natural persons who consent, okay, because Sharn Importing Ltd. Through its director started the action in BC, it was consenting to the jurisdiction. So bingo, BC has jurisdiction. What's the forum? Well, that's dictated by the nature of the action. For example, in criminal matters, it's a criminal matter, so the forum is the criminal courts. But in civil matters, it's a little less obvious because you could go to small claims court in BC or you could go to the BC Supreme Court. In Ontario, they have small claims court, they have high court, and then they have the Superior Court, I think it's called. So they have three levels there with different jurisdictional amounts, okay? But in BC, you got two choices. Well, how did we wind up in the BC Supreme Court? Because it's concerning a guarantee for a substantial amount of money in excess of small claims, okay? So we now know jurisdiction and we now know forum, but then we get to law, and this is where things get a little interesting. Choice of law, you look at the most significant relationship doctrine, and we'll see in the case that they do that. And we look at the place of contracting, negotiation, place of performance, location of the subject matter, nationality, domicile, or the residence of the incorporating parties. All right? So let's go to the case and take a look. Wilson, CJSC, Chief Justice of the Supreme Court. On page 21 of the lecture materials, and which is page 350 of the actual case, that's where the judgment starts. And after some preliminary matters, the judge says the defendant, Babchuk, lived for many years in Vancouver. Okay, and he ran his company from Vancouver, and the bank account for his business was in Vancouver. So there's the nexus. Okay, that's how they say. Okay, that's the how we can establish the forum. Then he said the issue is the execution in favor of the plaintiff of a guarantee, and what the problem is different laws, conflicts of laws. In Quebec, it would be civil law that applied. We don't even know what that's about. In BC, a guarantee signed under seal is enforceable. In Alberta, it's different. If a guarantee is signed under seal but is not witnessed by a notary public, then it is invalid or void. So Babchuk is taking the position that he gave a guarantee, but it's void. The business in Quebec wants to enforce it. So what happened? The Sharn Importing imports shoes and then sells them to retail outlets. Babchuk has a store in Vancouver. He's been dealing with Sharn Importing for quite a while. He opens up another store in Edmonton. He wants to deal there. He gets the shoes on credit, 30, 60, 90 days. Okay, so he gets the shoes, sells them, pays Sharn Importing, and then makes a little bit of profit. The Edmonton store goes insolvent, and the shoes are either sold, stolen, disappeared, whatever. I suspect they probably got moved to the Vancouver store, sold, and the money kept illicitly. Anyway, the point is, Sharn Importing had been supplying goods on credit to the Vancouver operation. Now he's going to supply goods on credit to the Edmonton operation, and Sharn Importing says, well, wait a minute, okay, we're willing to do that, but we want personal guarantees, okay? So Babchuk signs a personal guarantee, and then the store goes insolvent. The Sharn Importing from Quebec starts a lawsuit against Babchuk. Babchuk says, oh, it's invalid because it was signed in Alberta. Okay, question. Was it signed in Alberta or was it signed in Vancouver? And it's not clear, and it gets muddier as to where it was signed as we go through the case. Okay, so first thing the judge does is he looks at the document. There is nothing on the face of the document to show where it was executed. Joint and several liability, though. Okay, so they've got the manager of the store on the hook, but he probably doesn't have enough money. It's going to be a dry judgment. So they want to get the owner, which is Babchuk. And it's the whole point that the corporate veil would protect the owner, Babchuk, from liability, right? Because if you pierce the corporate veil, you cannot go after the owners or the shareholders. All right, at the top of page 351, he said that the business, the store, Alronda, went insolvent and the creditors received nothing. So there were other people who owed money besides Sharn Importing, and they didn't get anything. The key point, the defendant admits that he signed the guarantee and meant to be bound by it. So Babchuk says, yeah, I signed it and I meant to be bound by it, but gosh, if I don't legally have to pay, why would I? Okay? Because under the Guarantees Acknowledgement Act in Alberta, which BC doesn't have, such a guarantee had to be executed in front of a notary public. Farther down the page, we see something that happens every once in a while in court cases, and that's the shifting of the burden. Remember we talked about the criminal law matter and a civil law matter, and civil law matters have to be decided on a balance of probability. Well, the balance of probability generally means that the plaintiff has to make out his or her case, okay, and find in their favor. Every once in a while, though, the judge says it would be inequitable to expect the plaintiff to do it, and they shift the burden to the defendant, and that's what they do here. The burden and onus of proof of this defense rests on him, on Babchuk. Why? Because whether it was signed or not in Alberta is within his knowledge. Sharn Importing received it in the mail after execution, so they have no way of knowing where or when it was signed, other than the fact that it was dated and signed. Okay, at the top of page 352, point 2, it says, because the fact is particularly within the knowledge of Babchuk. Then he quotes Wigmore. Wigmore what? Wigmore on evidence. This is one of those qualified legal publicists that is a source of law in international cases. In a civil matter in British Columbia, you do not bring in textbooks. Okay, you do precedent, you do law. Only in rare circumstances will they bring in textbooks, and usually it is in an international case like this. Farther down the page, it starts a paragraph. I trace first the history of the pleading asserting the guarantee was executed in Alberta. The pleadings. The plaintiff files a statement of claim, and they file a notice of civil claim which starts the action. Then they file a statement of claim outlining all the details. The defendant files a statement of defense. Well, Babchuk files a statement of defense, does not plead the Guarantee Act. Files an amended statement of defense when he actually mentions the Guarantee Acknowledgement Act. But he doesn't get around to actually pleading that as a defense until his third amendment to his statement of claim. So the judge looks at that, and obviously what he's saying is that's a bit suspicious. It's like, an afterthought. Hey, here's a way I can get out of paying. Then at the bottom of page 352, he says, now we'll deal with the defendant's evidence. And you can read that yourself. It was incredible. He could, I signed it in Edmonton. Well, do you have a plane ticket for when you flew there? No. Do you have a hotel ticket or receipt where you stayed? No. Do you have any meal receipts? No. But I know I was there. And then they said, okay, if you weren't there on that date, because you don't have any proof, are you sure you signed it? Oh, no, it was another day. I remember now. And he kept changing his story, and he kept coming up. Oh, I wasn't in Edmonton, it was in Alberta. Oh, I was in the States, and I was coming back to Edmonton. At one point, he even said he stayed at his sister's place, but nowhere did he have any receipts from hotels, airlines, gas receipts, or meals to suggest when he was in Edmonton at the time this document was actually signed. And at one point, when he was talking about how the judge was talking about how he changed his story, it says, after this was one idea was dismissed, this spurred him to new efforts. So obviously, the judge is just not buying this. And then at the bottom of page 353, the judge says, I found his story, or rather his succession of stories, which could easily have been verified by other evidence of friends with whom he stayed, or hotel registers, ticket stubs, completely incredible, particularly so because he is, I am sure, the sort of man who would keep most careful records for income tax purposes of business trips. So he's dealing with the veracity of the defendant's testimony. He doesn't say, he's trying to perpetrate a fraud, because fraud is so hard to prove, okay? Because there has to be mens rea and actus reus there, the guilty mind and the guilty act, where if you can just say, this is a number of years after the event and your recollection is not as good as the other parties, I believe him more, then the courts can do that a lot easier, and that's called the veracity of the testimony. Okay. He said the matter to be proved was particularly within his knowledge, and he failed to do so. So he has not established that it was signed in Alberta. But that leaves open the possibility of an appeal. And this judge is very clever. Wilson was a very, very well-known judge. He decides he's going to close all the doors. He said, but if I'm wrong in this finding, and if I were satisfied that the guarantee was, in fact, executed in Edmonton, I would still dismiss the action on the grounds of the law of Edmonton should not apply to the case. Okay? Wow. On the grounds of the, okay, it was executed in Edmonton, but it still wouldn't affect it. No, I flipped the page the wrong way. Sorry. I'm flipping that the wrong way again. Here we go. The Alberta law is not the proper law of the contract before me. And he cites Dicey's Conflicts of Laws, another publicist, a well-qualified publicist, who set out in his textbook a number of rules. And Rule 127 of Dicey, and that's not particularly important anymore, but the idea behind the rule is, it says, you look to see the closest and most real connection. Okay, so right on slide 63, rather, we see the most significant relationship doctrine. Same thing. Okay. Okay. First step, look at the contract. Is there a clause expressly stating the law? No. Second step, he goes to case law to support Dicey that you should look for the closest and most real connection. And he looked at the Mount Alberta Borough Council versus a defendant. Okay, and he said, all right, so how do we establish this most significant relationship doctrine? We have 5 points on slide 63, and he looks at the first one, the place of contracting. Okay, where did the parties actually contract? And then they look at the place of negotiation. So the first presumption is lex loci contractus, lex loci, the law of the place where it was contracted. And then the second presumption is lex loci solutionis, which means where the place of performance. Okay, so they don't look at the number 2 point. So he discusses them. And then he discusses the Mount Albert Borough Council case, which goes on to say, at the top of 355, English law, in deciding these matters, has refused to treat as conclusive, rigid, or arbitrary criteria such as lex loci contractus or lex loci solutionis. Why? Well, they go on to say, in each case, on a consideration of the terms of the contract, the situation of the parties, and generally all the surrounding circumstances have to be looked at. So you look at these, but you don't just say, aha, it's one of these, or oh, it isn't one of those. So these are guideposts. They're not. You're not looking for the one to put the stamp on. The place of performance of the contract was not and could not have been intended to be Alberta. Why? Well, we have the contract for shoes going, the shoes going this way and the money going that way. No, that's nothing to do with the guarantee. Okay, that's to do with the contract between the shoe selling company and the shoe supplier in Quebec. The guarantee is going to be performed by having the money paid to Sharn Importing in Quebec. Okay. The debtor is bound to seek out his creditor. That is an absolute rule. Stepping aside for a second, there was a case not too long ago that I was involved in where somebody rented premises, business premises, and they paid their first and last month's rent, and they move in, and the next month, on the first of the month, the tenant's got his check there, and he's waiting. He's got the check, and he's waiting and waiting. But the landlord doesn't come and get it, and so he goes, oh well. Next day goes by, and landlord isn't. When's the landlord going to come by and get the money? And then the third day he comes to work, and there's a lock on the door, and there's an order of forfeiture. Why? Because he had not paid his rent, and he said, but I was ready and willing and able at all times to pay my rent. And under the lease, it clearly says you have to pay the landlord. Well, that doesn't mean that the landlord has to come and get it. What it means is you have to seek out the landlord and get the money to him. And so the forfeiture held, okay? Same thing here. He has to seek out his creditor. Okay, where's the creditor? Quebec. Oh, problem solved. Then obviously, if it's to be performed, place of contracting, was it in Vancouver? Was it in Edmonton? Was it in Quebec? Was it done by mail? Was it done by telephone? So they couldn't nail it down. Place of negotiation, same thing, right? So did all these things are not determinative, but they get to place of performance. Obviously, has to be performed in Quebec. So the judge has his answer. Okay, you look at them all. All the surrounding circumstances. Well, place of performance, and then you look at the doctrine that the person has to seek out his debtor, and obviously it's the law of Quebec. So we now have jurisdiction in BC Supreme Court. We know the BC Supreme Court is the correct forum, and they apply the law of Quebec. So the judge turns and he looks at the lawyers in the courtroom and he says, okay, the law of Quebec. Who can prove what the law of Quebec is? Well, they're both common law judges, or lawyers, and they sort of look at each other and go, I don't know, it's in the Quebec Civil Code, and I don't have a copy, I don't know where to look. So the judge says, oh, okay. The next rule then is set out again in Dicey, where foreign law is not proved, the court applies English law. English law, well, what English law? The English law of Alberta? No, because it's a BC court. Okay, so the judge says, I get to apply BC law. A guarantee signed under seal, valid. Doesn't matter where it's been signed. Okay? All right. So you think, okay, now we can all go home. No. Babchuk says, well, wait a minute. No. To be performed, aren't we talking about the performance of the contract? And the judge says, no, very clearly, we're not talking about the shoes and the payment for the shoes. We're talking about the guarantee. The judge isn't satisfied. He's going to put another nail in the coffin that's going to make it impossible for Babchuk to appeal. You think you have a right of appeal? No, you don't. You have to have an error at law or an error on the facts before you can appeal. So he then looks at the whole concept of the choice of law in favorem negoti. What's that mean? Well, it's a rule that isn't even on the most significant relationship doctrine. It goes to another sort of another avenue, and that is, what did the parties intend? Did they actually intend to negotiate and enter into a contract in... I'm sorry, actually, it is on the list. This is the negotiation one, the third point. Did they intend to negotiate and sign a contract that they knew was going to be invalid? No, obviously, they intended it to be valid. So again, he cites Dicey, midway through page 356, choice of law in favorem negoti. It has been said that the court may incline towards applying a system of law under which the contract would be valid because, so it is said, the parties cannot be assumed to have intended to contract under the law by which their agreement would be invalid. Okay? And then he cites some case law, and that's the judicial decisions. And he said, obviously, they intended a law to apply which would enforce the contract because words out of Babchuk's mouth, the defendant has sworn that he meant to be bound by the contract, and this avertment appears to me to add special strength to the argument for applying the system of law under which the contract would be valid. Okay? So if we're looking down the lists, my apologies for the one slip, but they looked at the place of contracting, inconclusive. They looked at the place of performance and said, okay, that says Quebec law. Can't do Quebec law, we'll do BC law. And then just to be sure, he said, okay, let's just look at this one other point, the place of negotiation. And said, all right, obviously they could not have intended to enter into an agreement that would be invalid. So they looked at the first three things on the list. Now, the fourth thing on the list they didn't have to look at, subject matter, because there was no subject matter. Okay. Nationality, domicile, residence of the or place of incorporation of the parties. Well, those were actually irrelevant to this particular case, so they didn't look at those either. So, perfect case because it shows an international setting. It shows the application of jurisdiction, forum, and most particularly choice of law. And it also comes back and shows us how judicial decisions come into play and how the writings of qualified publicists come into play. So it's a really good case, and I really think that you should take a close, hard look at it for examination purposes, knowing the definition of pleadings, documents filed with the court in order to commence or defend against a legal action, and you should know style of cause, which is basically just the name of the case. Let's see, anything else we should talk about? No, that's about it. Now, I did mention corporate veil, but this is forms of business organization. We don't get into that a little later on, so you don't have to worry about the corporate veil comment, but the rest is good fodder for the canon that I'm going to shoot at you in the way of a midterm examination. All right, so that concludes that chapter. Thank you very much.